Well, hello there again, my friend. Welcome back to the channel. My name is Gavin. This is my channel. Not terribly creative when it comes to naming channels, but you know what I am good at? Cutting through the fluff. Cutting through the sensationalism of true crime. I don't know why I've started doing that. It's just so dumb. But that's what I feel like I'm good at. And that's what we're going to do tonight. We're going to continue our look into the motions that were filed back in February by the defense team of Stephen Stearns. That's what we're talking about tonight. And we are the reason that this has kind of come up is the prosecution has responded. And so we're going to talk about this. This is really important, guys, because what the defense is saying is that the police done messed up, and that in their mess up, they may have tainted any evidence that they gathered in their case against him on the SA grounds, not the other case, just SA. And when I say just, that's not a diminution. I'm just saying only. Out of the two, we're only talking about this one, okay? So let's talk about what case we're talking about. This is Madeline Soto, 13-year-old little girl, middle schooler, junior higher, whatever they call it in your area. 13 years old. She had just had her birthday. She had just had her birthday party the night before she went missing. The story that was given by Stephen Stearns, her mom's on-again, off-again boyfriend, was that Madeline slept on the way to school and he dropped her off. Dropped her off at school, something that he never did, but he did that morning. And then when her mother, Jennifer Soto, went to go pick her up, she was nowhere to be seen. Of course, she was nowhere to be seen because she was already deceased. And police say that it was Mr. Stearns who took her life and discarded her little dead body unceremoniously and disrespectfully in a field in Osceola County, Florida. Since then, Mr. Stearns has been charged with a 5-year protracted series of and I'm trying to keep this friendly for YouTube. I want this video to get out there, but we'll just say of SAing. He SA'd her for 5 years, and apparently he documented it photographically and videographically. One of the main pieces of evidence that they have against Mr. Stearns is they found 1,700 photos and videos in his Google account, on his Google Drive, that depict this protracted use. I don't even know what to say. I wish we could say the words on YouTube, but you guys know what I'm saying. That for 5 years he did that to her. Now, the defense is like, hang on a second. Nay. The police did not do a proper job of basically protecting my client's rights as they gathered evidence against him. And so what I thought I would do tonight, because we had some questions the last couple of times that we've talked about this, I thought that I would go through a couple of important ideas in the law. Now, keep in mind that I am not a lawyer. I am not even close to a lawyer. I don't even play one on TV. Like, I'm not a lawyer. And I also want to preface this by saying that what I've done here, what I'm about to show you, is grossly simplified. And there's never been a question that I have ever given a lawyer, that I've ever asked a lawyer, that didn't come back with, well, it depends, or maybe. Because there's so much ambiguity in the law because it's so complex. So I want you to keep that in mind, okay? But with that preface out of the way, let's talk about a couple of important ideas. And the reason that I thought that this would be a good idea is because in our last video, you're like, well, people would say, not all of you, but some people say, well, isn't the fact that she was missing probable cause or exigent circumstances and that those kinds of things? So let's talk about these very, very important ideas, these concepts within the law, starting with probable cause. What is probable cause? Okay, probable cause is a reasonable belief based on things that you know, things that are facts, okay? It is a belief based on facts that a crime has been committed, that a particular person was involved in the crime, or that evidence of a crime can be found in a certain place, right? And now this is something that you probably have heard, the phrase articulable probable cause, can you articulate probable cause? The reason that's important is because probable cause is something that you must explain to a judge, right? So you must be able, when I say you, I'm talking about police officers, they must be able to articulate what their reasonable belief is, right? So here are a couple examples of what probable cause is, and we're going to get into a couple examples of what probable cause isn't. So here's an example. You see somebody with your own eyes, you see somebody breaking into a car. A witness or an officer or whomever sees that person using a crowbar to open a car window. There's a crime in progress, and the officer, say the officer is the person who saw it, has probable cause to arrest that person. Or there's a witness that says, I saw it with my own two eyes. I know it to be a fact. Then the officer has probable cause. Here's another idea. An informant tells police that somebody is selling drugs in a house. And, that alone is not probable cause, and police have seen people going in and out quickly, and it is a known place where the purchase and selling of drugs exists, okay? It's not just a tip. There's also observable behavior that supports what the tip said. There's specific observable facts that would establish probable cause. Another one that is actually kind of, this one's a little borderline, because I know in some states, California specifically, the smell of alcohol or the smell of marijuana, for example, isn't enough to establish probable cause by state statute. But in most cases, say, okay, I smelled something. The odor of alcohol is coming off of a person in a car that I pulled over for swerving as a police officer. And not only do I smell the alcohol, but I see an open alcohol container. Okay, I have witnessed the swerving. I have witnessed the odor, and I have witnessed the open can. All of those are facts that suggest that driver might be under the influence. Therefore, I have probable cause to investigate. And I know that those are super simple, very simplified, examples. But let's talk about stuff that might feel like probable cause, but actually isn't. If a police officer says, oh man, he looks suspicious, or a witness says, I suspect that Gavin is doing this illegal thing. Well, suspicion just isn't enough. There has to be specific facts. Suspicion under the law is too vague unless it's backed up by more details, like a witness saw a suspect and can give you a description, and that description matches to the person that you're talking about. just suspicion alone is not probable cause. And we're going to get to Stephen Stearns here, but let's think about these things. Say you're in a high crime area. Say you're south of the 10 in Los Angeles, right? You're in South Central LA. It's known to be a high crime area. Just because you're in a certain neighborhood, that doesn't give police probable cause. They need more. They need to have observable facts or witnesses that have seen those observable facts. Another one that a lot of people, actually police use this one. Why are you acting so nervous? Nervousness around police is not a crime. It's not enough to establish wrongdoing. It's not enough to establish probable cause. It has to be married to an observable fact. Okay? Here's the easy way to remember it. Think of probable cause like it's a puzzle. If there are a few solid pieces in place, ones that clearly fit together that you didn't have to force together, and there's enough of the picture to guess what the entire puzzle contains, then you have probable cause. But if you just have one random piece, that's not enough to know what's really going on. Make sense? All right. What is reasonable belief? This is something that is honestly extremely important under the law, but also very confusing, and a lot of argument goes on about this all the time. So this is super simplified. But reasonable belief means that a person thinks something is true based on facts, evidence, or circumstances that would make the average reasonable person agree that it's likely to be true. It's not a guess, it's not a feeling, it's not a hunch. It's what is reasonable. It's what an everyday person who is endowed with a certain amount of reasonableness and intelligence, it's what they would believe if they saw or knew the exact same things. Okay? It's kind of tough to it's kind of tough to perfectly define it. In fact, there's a what was the Supreme Court case decision that I was just reading on SCOTUS blog yesterday? I'm blanking on what it is, but it boiled down to the reasonable person standard, right? Reasonable person, would they or would they not believe the same thing if they had the same facts? Think of it like this. Imagine you're walking down a street, you see smoke pouring out of a building and people running out coughing. Even if you don't see the flames, you'd have a reasonable belief that there was a fire, right? Now compare that to you see someone sweating and pacing, you say, I bet he just robbed a bank. Those two things don't connect directly. That's a hunch. It's not a reasonable belief because there are no facts supporting it. Another example of this that is given in court all the time here in the Commonwealth of Pennsylvania is if you went into the movies, you go into a movie theater, and as you're walking in, you look up in the sky, and it's a blue sky, the sun is out, and it's a beautiful day. You go in, you watch your movie. When you come out, you look in the sky, and it's a blue sky, and the sun is out, but when you look at the ground, it's soaking wet everywhere. It is a reasonable belief to believe that it rained while you were in the movies. Another example of that would be you go to bed one night and there's no evidence that it has snowed, but when you wake up in the morning, you go outside and there's snow on the ground. A reasonable person would come to the conclusion that it snowed during the night, right? So there are lots of these examples, and it's really hard to put a lasso around exactly what it is, but those are the examples, right? What would a reasonable person think if they had the same facts as you? All right, so in law enforcement, for police to have reasonable belief, it must be based on witness statements, what they see, what they hear, and other evidence like security footage, like tip from a reliable informant, and so forth. They can't just have a reasonable belief based on a hunch. Okay? Here's another example of a reasonable belief. A store clerk runs outside and tells a cop that guy just stole a bunch of stuff and ran out with it. The officer turns and sees a man sprinting away with items still tagged and stuff in his backpack. That officer would reasonably believe that that man had just committed theft. Okay? Here's something that's not reasonable belief. A cop sees a young man sitting in a car in a parking lot late at night. No crime reported, no laws broken. If the cop says, he just looks like he might be up to something, that's not a reasonable belief. That is a gut feeling. And we're going to apply these as we read some of these arguments that the lawyers are making on each side, okay? Let's talk about exigent circumstances. Exigent circumstances are emergencies. They're emergency situations where law enforcement is allowed to take action without a warrant because waiting to get a warrant would risk danger, destruction of evidence, or escape. So basically it means something urgent is happening right now and there's no time to get a judge's permission. And I think this is important because the prosecution is arguing exigency. The defense is saying no exigency. So why exigent circumstances are allowed? The Fourth Amendment protects us from unreasonable searches and entries without a warrant, right? But the court recognizes that in a real emergency, safety and justice might outweigh the usual process. Well, we'll get into a couple examples, okay? Someone is screaming for help inside a house. Officers hear cries like, help me, from inside a home. They don't need a warrant to go in because they're protecting life. It's an emergency. Say police are chasing a suspect who runs into their house. It's called a hot pursuit. Officers can follow them in without stopping to get a warrant, right? This one is the one that I think applies to this case. Evidence is about to be destroyed. Police knock on a door and hear toilets flushing and shredders running. They can enter to prevent destruction of drugs, documents, and so forth. Okay? Another example, there's a fire, there's a gas leak, there's an explosion. First responders or officers can enter without a warrant to deal with the emergency. That's what exigent circumstances are. Here are a couple things that are not exigent circumstances. The suspect might destroy evidence sometime later. Now, this is going to be the argument, or this is the argument that the defense and prosecution are having, right? In this case, prosecution is like, we needed to get it because he was going to destroy evidence. The defense is going, what do you mean? He had already factory reset his phone, right? So there's that argument there. So typically that's not urgent enough to skip a warrant. They have to get a warrant. Okay, it's late and getting a warrant is inconvenient. Inconvenience is not an emergency. Officers think someone could be in danger but have no actual signs of it. They need real indicators, screams, little drops of blood, like a trail of blood, threats, those kinds of things. They can't just feel it in their bones that somebody might be in danger. All right, so here's a key rule of thumb about exigent circumstances. If it's truly an emergency that cannot wait and there are specific observable reasons, then it might count as exigent circumstances. But if officers have time to call a judge or get a warrant first, they're supposed to. If they've got time, then it's not exigency. It's not an emergency, right? Okay, the last one that I want to talk about is this metaphor, the fruit of the poison tree. What is it? Okay, it's a legal metaphor that means if the source of the evidence, in the metaphor this would be the tree, is tainted by illegal actions by investigating officers, for example, like an unconstitutional search, like an unconstitutional seizure, like an unconstitutional interview, then anything that comes from it, which is considered the fruit, is also tainted and usually can't be used in court with some limited exceptions. Okay? This comes from what is known as the exclusionary rule, which says that evidence obtained illegally, which would be like the examples that we just talked about, violating the Fourth, Fifth, and Sixth Amendments, cannot be used in court. The fruit of the poisonous tree takes that rule a step further, even evidence. So the exclusionary rule says anything illegally obtained can't be used in court. The fruit of the poisonous tree doctrine takes it further, says even evidence that resulted from that illegal action is also excluded. And this is the crux of the argument here. And by the way, I keep feeling like it sounds like I'm on the defensive side on this. I'm not on either side on this. I'm commenting on both things. I'm on the side of justice for Madeleine. That is what I want. I want her essay, her multiple times, all of the times that she was essayed, and her murder. I want those to have justice served. That's where I am. Now, I'm very I get very animated about any type of corruption or misconduct on the part of people that are endowed with power. You guys know that, you may not know, but longtime viewers know that I applied for and was accepted into a police academy early in my career, and at the last minute there was a fork in my path and I took the other fork. But during that whole process of applying to get to the police academy, one of the things that was kind of like hammered into our brain is we really want to weed out the bad folks here, because you will be endowed with power up to and including taking a person's life. And so for those people that have that endowment of power through the oath of an office or statutorily speaking, whatever, elected officials, whatever, they need to be held accountable and make sure that they are working within the confines of the power that is given them. And any time that they work outside of those boundaries, those restrictions, they cannot be allowed to get away with it, even if that means that justice for a beautiful little 13-year-old girl can't come. And I mean, that's the hard reality. That is the difficult thing. We have to consider the many before we consider the one, because if Mr. Stern's rights were taken from him illegally and they get away with it, then that could happen to you and that could happen to me. And that is the really hard part about all of this, is that we want justice for Madeleine. We want her killer and her SAer to face justice, but not at the expense of the fidelity and the integrity of the law. Okay, let's see. What do I have here? Okay, here's an easy analogy. We're talking about fruit of the poisonous tree again. If a police officer illegally breaks into a house and finds a map to buried drugs, and then goes and finds the drugs using the map that he found, they can't use those drugs as evidence against the suspect, let's say. I know that's missing pieces, but you guys get it, right? Here are a couple of real-world examples. Police search someone's phone without a warrant or consent. They find text showing where stolen goods are hidden. They go to that place, recover the stolen goods. The stolen goods equal the fruit of the poisonous tree, which equals not admissible in court. So the question before us is, was the seizure and the search of Stephen Stern's phone, it all starts with the seizure. Was the seizure a poisoned tree? Because if that seizure was a poisoned tree, then the fruits, which would be the search of the phone, the search of the Google Drive, are the fruit of that poison tree, and that is scary. Okay, let's talk about exceptions. Again, nothing's easy under the law, right? Courts don't always exclude the fruit. Here's a couple of examples of when that fruit might still be allowed. Say there's an independent source. Say the police find the evidence from a totally separate legal method. For example, a witness reports the location of stolen goods before police searched illegally. Then the fruit is allowed. Another one is inevitable discovery. Police would have found it anyway, even without the illegal action. So a search team was already headed to the location legally. Then the fruit would be allowed, even though the fruit was tainted. There is the attenuation doctrine. Enough time or distance between the illegal act and the discovery makes it less connected. So, for example, a suspect confesses days later at a legal voluntary interview. Then the fruit would be allowed. But they're very limited. The exceptions are very limited. Now, I know this is a repeat, but this protects people's rights and it keeps law enforcement accountable. If police know that they can't use evidence from unlawful searches, they're way more likely, the incentives are there for them to behave legally. I think that's all I got. Yep. All right. So with that in mind, let's go over to your comments real quick, see where you guys are at before we hop into some documents, okay? Going to refresh my screen here a little bit. Let's bring up Maddie. Okay. I don't know. I'm not going to get all of your comments. I'm sorry. I try to, but I'm not going to get all of them tonight. JPL, Jay the Stelladoro says, at this time, Gavin, did they know about the dumpster footage? I'm actually not sure about the timeline. Not sure about the timeline. But let's say that they did know about the dumpster footage. Is that enough for them to get a warrant for Stephen Stern's phone specifically? I think probably not. However, the traffic cameras showing him driving all over the place might be enough for them to get the phone records. I don't know if it would be enough for them to get the phone. So, I mean, it's just, I mean, they're going to argue about this for sure. Oral arguments on this are April 23rd. There are going to be compelling arguments on both sides, and a judge is going to have to take it under advisement. We will see. Built to Help Art says, Gavin, Stephen Stearns could have reset the phone and loaded a second SIM or micro SD that might have been in the phone and could imminently be destroyed. Yeah, I mean, that is certainly an argument to be made. And I think that's sort of like the argument that the prosecution makes, at least in the documents that we read yesterday in the last couple of days. The ones that we're reading tonight, I haven't read before. I like to be able to read them for the first time with you guys. Hey, somebody's from Quito, Ecuador. Maggie Gomez, welcome. Suramericana, glad that you are here. Let me scroll down here real quick. Lisa says, Gavin, you are on the side of doing things the right way. That is where I am. Yes. How do you feel this whole ordeal may affect the unaliving trial? I think that there's such a big mountain of evidence in that side of things that it's going to be, they're going to be fine. I really think so. Even if they lose, if the prosecution loses what's happening here, I think that there is plenty of evidence. I mean, crying out loud, Stephen Stearns admittedly shared a bed with her, was the last person to see her live. He lied multiple times about what he did that morning. There's video evidence of him with her little poor dead body in the car with him. There's video evidence of him moving her body into the trunk. I mean, there's so much that I think that case is going to be fine. This case, though, I mean, I think that there are issues. I think there really are. Great question. Thanks, Tyson. Just Ducky, Gavin, you may not be a lawyer, but we love hearing from Uncle Gavin. Yeah. Built to Help Art says, unless they come to the same evidence in another unrelated way. Indeed. Yes, Rita, he still is charged in her murder faux show. Vlad says, Gavin, cops didn't act in bad faith. Defense is arguing a technicality. I mean, agreed. It is a legal technicality, but an important one. I mean, for crying out loud, there are some seriously famous cases that we all know about where people got off on a technicality, right? Bill Cosby admitted to what he was doing, but because he had made an agreement with the prosecutor that said, you can't prosecute me for this, and then the following prosecutor said, yeah, no, I'm going to go ahead and prosecute him for this. He got off on appeal, if I remember correctly, on a legal technicality, right? These technicalities are very, very important. Very important. Kathleen says, but it wasn't illegal. They had asked. Sort of. I mean, or I think the answer to this question, Kathleen, is maybe, which is a very lawyerly thing to say, right? Like, honestly, I've never asked a direct question to a lawyer and gotten a direct answer. And I'm talking about my friends who are lawyers, people that I know and care about, in addition to those that I've hired over the years, right? I've never gotten a direct answer. I think the answer is maybe. We can't really speak in absolutes here, right? It could be that you are right. And for Madeline's sake, I hope that you are. But not necessarily, right? Art's on fire tonight. Gavin, regarding the academy in New Jersey, people take a test prep course for the exam that includes helping you navigate the psych interview, allowing too many through the pipeline. That's interesting. I didn't do any mental or emotional prep work. I did physical prep work for sure, but I didn't find the questioning all that difficult. And I did it in the state of Nevada. Kathleen, they said, can we look through your phone or do we need a warrant? Stearns said it should be okay. Yeah, that is a true fact, but that is what the argument is the seizure that happened before that. That's the thing. Like, I'm not defending one side or the other here. I'm hoping for justice for this little girl, but I'm not defending either side. That's the argument. Is that, yes, they did say that, but that's not really the question, because according to the defense, the phone was seized 9 hours before that. The prosecution says 4.5 at tops, right? So there's an argument to be made. Norma says, Gavin, did the law enforcement officer obtain a written consent? Not according to the defense. Didn't. What if Stephen Stearns said no to handing over the phone? I mean, honestly, he should have said no to handing over the phone. That's what he should have done. Super Charismatic says, Gavin, and that's why they call it practicing law, because it's all so nuanced. Indeed, indeed. Okay. Fisher Blue's making the same argument. Asked him every time and didn't have his pin to go into the phone until the second interview and said, or do I need a warrant? So she brought that up. They couldn't go into the phone without the pin. I do believe that the Tagler, I think was the detective here, probably had a belief that he would destroy evidence. The question then becomes, was it a reasonable belief that he would destroy evidence, therefore giving her exigent circumstances, right? Pretty great. Carol says the judge will be the final arbiter of fact in this case, but won't want to make it an appealable case. Yeah, that is the incentive structure that judges have, right? They love the idea of going their entire career without an appeal ever winning because they judged on the merits of the law. And yeah. Sandra says, Gavin, if this gets dismissed, his attorneys will file a motion to dismiss the SA. The SA case is how they can go for the DP. This actually affects both cases. That's true. That is true. So high stakes for both sides. Man, you guys are so good. And I'm sorry that I didn't get to everybody's comments, but great comments. One of the reasons that I love you guys, this community that we have so far here, is that boy, are you astute, and boy, do you ask good questions, and holy cow, are your comments just so on point. I deeply appreciate everything about that, guys. You guys are amazing. Okay, shall we head on over here? Hang on just one second for me, guys. Oh, I've got a cover photo. What do I look like in my old cover photo? I bet I have short hair. Ha! Oh, look at that. Look at that. I need to make it bigger. Why is it? It needs to go there. Okay, give me just a second. Okay, you can hear me in the background. Okie dokie. I needed like a throat lozenge here. All right, here we go. What we're looking at here is page 3, the bottom of page 3 in the defense's motion back in February, okay? And I'm just it's the motion to suppress evidence obtained from unlawful searches of the cell phone. And this motion came in after the first motion, which was the unlawful seizure. All right? Everything starts at that seizure, though. I'm going to skip a whole bunch, and I'm just going to go to the statement of facts, okay? I'm going to skip through. I mean, we know this whole thing. Let me just kind of skip down to, all right. During the encounter, says the defense on number 7 here, during the encounter, Detective Tagler sought limited access to Mr. Stern's cell phone, specifically requesting only to check his Google login status by saying, is it okay if I go in your settings real quick? I just want to see if you're logged into Google. Mr. Stearns responded yeah to this specific request. Despite only receiving consent to check if you're logged into your Google, the detectives conducted an extensive unauthorized search of Mr. Stern's cell phone data well beyond this limited scope. Okay, so these are the arguments that they've kind of gone over. Let me kind of just skip down. Detective Tagler specifically stated, I was checking your call history and noticed that you don't have anything before this morning. Is that unusual on your phone? All right. At the conclusion of the interview, Tagler took possession of Mr. Stern's phone. Then Tagler stated, I'm going to hold onto your phone and I'll give it back to you when we're done. This, by the way, is like the equivalent of saying, I think that there is evidence on this phone. Well, the equivalent would be, I think there's evidence in that house, therefore I'm not going to let you back into your house. We're applying for a warrant right now. And I think that's kind of what she was doing here. We're going to take your phone because I think there's evidence there, and I don't want you to have access to it. I think that's what she was doing. At this time, Mr. Stearns expressed concern about contacting his father, blah, blah, blah. He was given no choice regarding the seizure of his phone. No consent was even sought, is their argument. And then they contacted him again. This was 9 hours and 30 minutes after the initial seizure of the phone. Detectives presented him with the ultimatum. We talked about this in our last one. Is this something I have your consent to do, or do I need to get a search warrant for your phone? And of course, you guys know, dude, never give consent. Don't do that. But that is what Mr. Stearns did. They argue that they pressured Stearns into providing his phone PIN by referring back to his prior consent. At this point, Mr. Stearns had only ever consented to letting detectives check if you're logged into Google. The second consent for the forensic download was obtained while the phone was already in police possession without lawful authority. So they're saying the seizure is the problem, according to the defense. All right. Let's see. The detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. They did not document any exigent circumstances justifying the warrantless seizure. And, they claim that he was high on prescription drugs, Ativan, so on and so forth. And then we get to 37. Okay. At approximately 2:40 a.m. on the 28th, Mr. Stearns' phone was taken to the Orange County Sheriff's Office Digital Forensics Unit. The phone was subjected to a comprehensive forensic examination using Cellbrite technology. Cellbrite, guys, is it's a combination of hardware and software that is used to connect to a phone and basically take a clone of that phone. It's beyond the technology that we have to clone phones on like the consumer level. Okay. The Cellbrite forensic extraction allowed detectives to access and examine not only readily available data, but also deleted content, hidden files, system logs, and other digital artifacts not normally accessible to typical users. The detectives accessed and examined personal data unrelated to the current investigation. Based on the data obtained from these comprehensive digital searches, the investigation was partially transferred to the Kissimmee Police Department due to jurisdictional issues. Detective Tagler noted at this point that the Kissimmee Police Department was advised of the findings from the Cellbrite forensic extraction, and Detective Corporal Brandon Ilgen and Detective Mark Morris responded to the Central Operations Center. During this invasive search, of course, they use prejudicial language like that in their argument, detectives discovered digital evidence that led them to seek additional warrants. One such warrant sought was for Mr. Stearns' Google account. Deputy Taylor Heller of the Orange County Sheriff's Office sought the warrant for Mr. Stearns' Google account on February 28, 2024, the same day as the Cellbrite extraction. The Google warrant application relied on information obtained from the illegal phone search. They're saying the phone search was illegal because the seizure was illegal. Therefore, anything that came out of the warrant for the Google Drive would also be illegal. Again, fruit of the poison tree. The Google warrant execution revealed over 1,700 files in a Google Drive folder. These files included photographs, videos, and other media files that form the basis of this instant case, the very case that we're talking about. The files contained associated location data and metadata spanning from 2019 to 2024. All evidence collected in this case, including the Google warrant results and subsequent police investigation, stems from the detectives' initial illegal search of Mr. Stearns' phone on February 27th. Neither detectives from the Orange County Sheriff's Office nor those from the Kissimmee Police Department sought a warrant to search the contents of Mr. Stearns' phone. Is that true? They didn't? Oh, because they thought they had consent. But the lawyer is saying they didn't have consent because the seizure was illegal. Therefore, the consent doesn't matter. Okay. All right. Now that we've done that, let's go over to the statement of facts from the prosecution. Okay, this is starting on page 2. This is the state's response to the defense's motion that we were just reading from. This was filed, 2 days ago. All right. They write it a little bit differently, and we went through most of this in the last one, okay? So Madeline is missing. They go and they talk to the defendant, Jennifer Soto. They look at Madeline's phone. There's statements, blah, blah, blah. I'm yada-yadaing this, right? Madeline, they haven't found Madeline. Stearns was the last person to be there with her. They did an audio recording of an interview with them. He claimed he left his phone at home. And I'm yada-yadaing these, but these are important to their arguments, just that we've been over this. Because they're establishing multiple facts in order to in order to support what they are saying is probable cause and exigent circumstances. And therefore, not fruit of the poisonous tree, right? So then we've got Tagler and Acosta coming. Defendant not in handcuffs was free to leave. He continued to lie to them about dropping off Maddie, the whole McDonald's story, and then he unlocked his cell phone and handed it to Tagler. By the way, Tagler is probably a really good cop. In fact, I've said it a million times. All of the documentation in this from all 4 technically, because the FDLE stuff, all 4 law enforcement agencies is really good. I think that these detectives are really good, but I do think that Tagler made a critical error in when she first said, hey, I just want to look at your settings real quick. She honestly just had to say, hey, can I look through your phone? Is that okay? And that's it. And he was so nervous, he would have gone, yeah, it should be fine. Right? That's what he ultimately said. Do you mind if I look at your phone real quick? Yeah, I'm just going to look through it. Is that cool? That's all she had to do. Her mistake was, and I think that she will never make this mistake again in her career. Her mistake was specifically saying, this is what I want to look at. That was a mistake. But I think she's a terrific cop and probably will not make that mistake again. And ultimately, maybe the prosecution wins this and it's moot, but she learns that she doesn't want to go through this process during the prosecution phase ever again and won't do it ever again. Okay, so she's looking through the phone. Can I take a picture of your history? Asks about logging into Google and all the stuff that we went through last night. I just want to see if there is more that they address what happened later. We talked about this yesterday. She says we're going to hold on to the phone, give it back to you when we're done. The whole thing, right? Okay. So they don't do anything about what happened later with the Cellbrite thing. They're just saying, okay, this is what happened, and here's our argument. Interesting. And this looks to be almost the exact same argument from the other response. Riley v. California, U.S. v. Gonzalez. Mincy v. Arizona, Kentucky v. King, Jimeno, Smith, Allen. They're making the same argument. They're making the exact same argument. Let's see Let's look at their legal argument. We're back at the defense here, okay? Law enforcement's actions in this case present a textbook example of how officers can systematically erode Fourth Amendment protections by exploiting a citizen's limited consent. Detective Tagler's transformation of narrow permission to check Google login status into a comprehensive search of Mr. Stern's private cell phone data epitomizes the type of incremental overreach that courts have consistently rejected, particularly in the context of modern digital devices that contain the most intimate details of a person's life. They talk about Norman. I think they talk about place, objective reasonableness. Most critically for the case at bar, when consent is obtained after illegal police activity such as an unauthorized search or arrest, the unlawful police action presumptively taints and renders involuntary any consent to search. Wong Sun v. U.S. is the very case that brought us the fruit of the poison tree doctrine. They argued, enhanced privacy under Riley. That is something that they argued before. Detectives systematically exceeded consent, conducted an unlawful search. Okay, now I yada-yada'd over it, but the prosecution was like, he didn't just say you can check my settings. He agreed to several things along the way, so I want to be fair about that. No reasonable person would understand this exchange as granting permission for a comprehensive search. The whole, can I look at your settings real quick just to see if you're logged into Google? And yeah. Okay. Let's see if there's any more. The state cannot satisfy Florida's consent requirements because the search exceeded all boundaries of the established consent. Okay. Most damaging to the state's position are Tagler's own statements demonstrating her knowing and intentional violation of the scope of consent by declaring, I was checking your call history and confronting Mr. Stearns with location data from Google Maps. Tagler herself documented that she deliberately ventured far beyond merely checking login status. And of course, the prosecution says, no, this was just tacit approval. He knew what was going on. But there wasn't, according to the defense, there was no spoken verbal actual consent. All right. State cannot articulate any legitimate investigative necessity that required Tagler to exceed the narrow scope of consent. Yet she should not have asked for that narrow scope. That was the problem here. That is the problem. Now, they, meaning the prosecution side, might prevail. But I still think that was probably the main issue. Okay, let's read this part. The subsequent consent to download the phone was involuntary under the totality of circumstances. The evidence in this case underscores how law enforcement's tactics crossed constitutional boundaries to secure purported consent for a comprehensive search. Detectives systematically eroded Mr. Stearns' rights by exceeding limited permissions, exploiting the prolonged seizure of his phone, and wielding coercive threats to compel compliance. These actions demonstrate a deliberate strategy to bypass constitutional safeguards, rendering any alleged consent involuntary and invalid under the Fourth Amendment. The state cannot meet its burden of proving that Mr. Stearns' consent to have his cell phone forensically examined was freely and voluntarily given, as required by established precedent due to the pervasive misconduct and coercion employed by law enforcement. This argument. Consent following illegal police actions is presumed involuntary. Consent obtained following illegal police activity, such as an unauthorized search or seizure, is presumed involuntary. Under Norman, the presumption of taint applies unless there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the prior misconduct. The state bears the burden of proving such a break, and without this proof, the consent remains invalid. This principle underscores the requirement that voluntariness must be free from coercive circumstances arising from prior unlawful conduct. Okay. Yep. Okay. Agree to that. Law enforcement's tactics demonstrated coercion when detectives seized Mr. Stern's cell phone. Yeah, I agree to that. I honestly, I'm having read the previous ones in totality. I feel like the law favors the defense on this, unfortunately. And boy, I hope I'm wrong. And I have no bona fides here, guys. So take it for what it is. We just law enforcement's coercion reached its peak with the midnight download request. Finally, detectives compounded their misconduct by employing the type of inherently coercive tactics explicitly condemned by Florida courts in Butler by suggesting that if the defendant did not voluntarily consent to a complete forensic download of his cell phone, they would simply obtain a warrant. The Second District has made clear that such implied threats to obtain a warrant invalidate any purported voluntary consent. Yeah, I mean, I know why cops do that. I mean, they're people, right? Are you going to make me get a warrant on this? Because I will. Just go get a warrant. Just get the warrant. Crying out loud. You know what they could have done? They could have gotten a warrant. They could have written an application and gotten a warrant during the very conversation that they were having with Mr. Stearns. It's not a long process, a couple of hours. They were already talking to him for a couple of hours. That warrant should have been written if they believed they had that probable cause. Maybe the issue is they didn't believe they had the probable cause. Really interesting. Rather than simply obtaining a warrant for either the cell phone itself or its contents, which according to Riley v. California can be accomplished electronically in less than 15 minutes, detectives chose to orchestrate a coercive late-night confrontation to pressure Mr. Stearns into consenting to a phone download at approximately 1:30 in the morning. This choice is particularly egregious given that the Ninth Judicial Circuit Administrative Order has long established a clear protocol in the Ninth Circuit for obtaining emergency warrants at any hour. For nearly 40 years, the circuit has maintained an emergency duty judge system specifically designed to handle after-hours warrants and other emergency matters. Yeah. Okay, so I honestly, guys, yeah, they nullify voluntary consent. I think this is well argued. I really do. All right, let's read the conclusion. Law enforcement's conduct in this case represents a flagrant disregard for the Fourth Amendment and well-established legal principles governing searches and seizures. Tagler's unauthorized expansion of the limited consent given by Mr. Stearns, the prolonged warrantless seizure of his phone, and the coercive tactics employed to extract consent for a forensic download collectively demonstrate an egregious violation of constitutional protections. Under the totality of circumstances, Mr. Stearns' purported consent was the product of coercion rather than a voluntary, knowing, and intelligent waiver of his rights. The detectives repeated overreach, first by exceeding the narrow scope of consent, then by unlawfully seizing and retaining the phone, and finally by leveraging its possession to coerce a forensic download under the threat of a warrant, renders all evidence obtained through these actions inadmissible. To uphold the integrity of the judicial system and safeguard against future unlawful searches, suppression is not merely appropriate, it is required given the deliberate and repeated constitutional violations in this case. Suppression is the only remedy that restores Mr. Stearns' constitutional rights and deters future misconduct by law enforcement, which flagrantly disregard established Fourth Amendment safeguards. And then they ask the court to set the matter for an evidentiary hearing, suppress all the evidence obtained from and derived through the unlawful searches of the cell phone, including but not limited to Cellbrite forensic extraction and the subsequently obtained Google account warrant, and 3, grant such other relief as the court deems just and proper. Okay. I as a non-judge, as a non-lawyer, am convinced that the defense is correct here. I mean, I know that I didn't read all through the prosecution's thing, and I really yada yada'd this thing, but based on the other documents that I read, they're basically the same arguments. This one's just a little expanded. I am compelled to side with the defense on this one, which really sucks because we're talking about the prolonged SAing of this girl from the time she was 8. And if the defense prevails on these motions, it is not the fault of the defense. It is the fault of law enforcement. Wow. And I also agree with this sentence here. Let me bring you back over. Right? This is what we've been talking about. It's this one right here. Let me just highlight it. To uphold the integrity of the judicial system and safeguard against future unlawful searches, suppression is not merely appropriate, it's required given the deliberate and repeated constitutional violations in the case. Yeah, if they prevail on this, it sucks for the case, but it would be the fault of law enforcement for their behavior. And I think that it's more likely than not that the defense prevails on this. But I'm just some guy talking on YouTube. It's just my opinion, guys. So, it's obviously there are people that are more qualified on this, right? Thank you very much to Kanun for the super chat. Does the fruit of the poisonous tree affect the other case? Yeah, so they're seeking the DP in the other case because they're saying that the murder was committed in the commission of another felony, which would be this case. So, yeah, possibly if they were to lose or the first case were to be dismissed, they still have enough to charge with homicide, with first-degree murder, but they probably wouldn't be able to seek DP. They probably wouldn't be able to get it anyway, which sucks in this case, right? I wanted to make sure. I think I saw something else too. Let me see if I can find this. I like to give deference to the super chats. Welcome to Fanatic Little Crimp. Glad you're here. Thanks for joining. Also to Kanun. Thank you very much. Appreciate that. And I know there's a super sticker in there somewhere. I just can't seem to find it. I'll get it by the end of the live stream. I'll find it. But I wanted to say thank you for those because my last 2 videos have been demonetized. It's really annoying. It's okay if a video gets demonetized here and there. It's perfectly fine. And you guys take care of me so well. My patrons, my members, you guys buy merch. You guys really help me to chase after this dream of being a YouTuber full time. But it was kind of a bummer. So I really, really appreciate those of you who are supporting me monetarily. Okay, let me get up to Where am I? Okay. Lisa says they could have used his browser to find those photos once he was arrested. You can access photos from the Chrome browser with the login. Yeah, but they're saying the seizure was illegal. If the seizure was illegal, then everything behind it is illegal. Graciela, my Uruguaya friend, right? Living in Australia. Glad you're here. Fisher Blue, they had the time to look at all the videos. They had lots of time. They had probable cause. What videos, though, are you talking about? Are you talking about the ones that were on his Google Drive? Because those are the ones that they're saying are illegal because they are fruits of the poisonous tree. Nancy just tuned in, but what about the evidence that Stefan's father turned over? I think that evidence will hold up. We're not talking about that evidence at all. So that's good. Chloe's mom, I can see why Tagler wanted to hang on to the phone. He had already factory reset it twice. Yeah, and the prosecution's argument was he'd already reset the phone twice, and they had let it slip that they wanted to see his Google account. So now there's exigency because they're afraid that he knows that they're going to look at the Google account. Now he's going to destroy evidence. Of course, all he needs is a computer to go in and destroy that evidence. I don't know. Super charismatic. It's hard to think about if you're coming from a place of empathy for Maddie, but if you're a law nerd, it will be interesting to see the outcome. Yeah, I mean, both things are true, and both can be true at the same time, that we want justice for Maddie, and we also want the integrity of the law to remain unmolested, right? Let's see. Jess says, Gavin, yes, absolutely reasonable belief he would destroy evidence again, considering he claimed to accidentally do it before. The actions of a suspect after the crime is still evidence. Legal seizure, in my opinion. I think that's a reasonable opinion. That's certainly the opinion of the prosecution. Norma says, love how level-headed you are and being the devil's advocate. Literally with for the demon in this case. Understand where you're coming from. Yeah, it's tough. It's tough to think about that kind of stuff. Tish says he'd already factory reset twice. It's reasonable to believe he would destroy more evidence. Yeah, I wonder if the judge is going to go, well, why would he destroy more evidence on the phone? The evidence isn't there. Of course, the prosecution, arguing with myself. Have you guys seen that episode of 30 Rock where it's time for Liz Lemon to negotiate her contract, and she has been a protege of Jack Donaghy, and so she is trying to use his negotiation tactics against himself, and it ultimately ends up that he negotiates with himself and ends up losing. That's how I feel right now. Oh my goodness. Tish Callahan Smith, if this case gets thrown out, that investigator should never work in law enforcement again. That's law enforcement 101. Yeah, there probably should be some sort of censure for that, for Detective Tagler. I don't know if firing is appropriate, because I think she did. I think she messed up. But I don't think that, I think it was probably, I think it's probably a mess up that a lot of people make in their careers. And it's one of those things that if she is caught out on it and Stephen Stearns walks on this case because of it, that will suck. There will still be the murder case and everything, but this will make Tagler, this already, I bet, has made Tagler just a much better detective already. So I don't know that firing her is the right thing to do, but some sort of censure, right? But I respect your comment there, Tish, and thank you for sharing it with us. Graciela, oh my goodness, every fish and water emoji possible. What's the deal with the watches? Michaela, is that how you pronounce your name? Michaela? That sounded Seinfeldian. Gavin, what's the deal with the watches? Do you know? I can't do accents, guys, nor do I do impressions at all. But secret SIM hidden in it? I don't think so. I think he wants money. I think that's all he wants. It's an Omega watch. You can get a few $1,000. Law enforcement knows that deleted files are retrievable, so they would probably have waited for the search warrant and not risked the case. Maybe? Yeah, that's the thing, is that those files probably were retrievable even if he factory reset his phone twice. He would have to reset it, load it to the gills, if you'll pardon the pun, and with data, and then wiped it again. It's just, I think they should have just sought an emergency search warrant. Would have been easy. Tom says, Gavin, what about the idea it's possible Jen is the ringleader? She owns Stefan and he works at her command. It's Jen that is the sheep in wolf's clothing. I think Jen bears some responsibility here. I think she should be held to account for that responsibility. Was she the ringleader? Man, if she is, then the wool is pulled securely and opaquely over my eyes. I just don't see it out of her. But, I mean, could be wrong. I frequently am. Super Kai's mad at Gavin. I was thinking last night, if he made plans to drive Maddie to school the night before and he never did that, does that not scream premeditation? Yeah, I think that probably could be used in the murder case that as evidence to the jury to show malice aforethought, to show premeditation, for sure. Yes. Kanun says, Gavin, I'm no lawyer, but couldn't the detective argue that she had the suspicion after he tells her that he has done factory reset by mistake, because pretty much anyone knows that's BS? So, I mean, that is the thing here, Kanun, is that the totality of the facts definitely support probable cause to me. And with that probable cause, they could have gone to the emergency judge and just gotten a warrant. And they should have. That's what they should have done. Yeah. Rachel Fay says, Gavin, Stearns, Soto, and Maddie were all said to have been upset on Saturday the 24th. Do you think this is premeditated, and what do you think led up to it? I mean, I've talked about this. We've speculated a little bit on this. There's one video I did about the whole pregnancy angle, whether she was pregnant or if she was pregnant or if she thought she was pregnant. Either way, the motive would be there to try to convince her to at least terminate that pregnancy, right? And if she didn't want to do that, then sure, that's motive for murder, for sure. Tonta37, Tagler was saying, does this make sense? So much that didn't make sense. Then didn't make sense. Yeah, she had enough for probable cause. 100%. She should have applied for a warrant. Dashelle Bailey Reese, or I think it's Reese, maybe Rice. Gavin, this case kills me because her birthday was 2 days after mine and she went missing. I was so sad when they found her dead and not hiding in the woods. Yes. Yeah, all of us have some kind of reason why this case speaks to us, right? For me, it's typically a paternal instinct. I just want to protect these little kids. And it just really angers and disturbs me when people that are in positions of trust take advantage of it. So, yeah, I understand what you're saying. Jess says, Gavin, they're arguing search and seizure are the same thing when they're not. They didn't have his password to the phone. They couldn't unlock it for a search without one. Well, the last document was about the seizure. This document was about the search. So I yada yada'd over it, I think, but I think that lawyer is making a good. So this is what happens sometimes, guys. This happens frequently in all sorts of different legal pleadings, motions, and so forth. Is a lawyer will say, they'll make their case, and then they'll say something like, but if you find against me on that, then this still applies. And if you find against me on that, then the next thing also still applies. They always tend to give the judge multiple ways to give them what it is that they want, right? I think in this case, that's what's happened here. They already did the seizure thing in the last one. In this one, they're doing the search. They're arguing that both of them are illegal. But I don't know. Again, could be wrong. I frequently am. Okay, let's see. Yeah, I think I might have caught up, everybody. Oh, here we go. Lisa, Gavin, the word settings is where the detective screwed the pooch on things. That is an unfortunate phrase that just tickles me for some reason. But yeah, sadly, I agree with you on the facts that she didn't do it right. Yeah, all she had to say was, hey, do you mind if I check through your phone real quick? He would have gone, yeah. That would have been it. Marginally gruntled. What a great handle. Marginally gruntled. Listen, marginally gruntled. I'm going to get to your comment here. Don't worry about it, but you got to comment more often, okay? Because speaking of being tickled, that tickles me. That is delightful. I love it. Okay. Gavin, if the defense prevails and they lose the pictorial evidence, will that weaken the prosecution of the murder charge in that the obvious motive looks weaker? Yeah, I do think that, I mean, possibly, but I think they've got so much on him on the other charge. In fact, I think that likely what if the judge rules in the defense's favor here, I think that the prosecution will find a way for an exception. Okay, guys, we need to find a way to get to that. We need to get to that evidence, and we need to do so legally. Get to work. I think that's what will happen, and I think they'll find a way. I think they'll find a way. All right. Just a couple more. Let's see. Sarah Kerbo, DNA on her equals reason to search bad image equals would have found it anyway. Sarah, I mean, that's a possible, yeah, that's a possible thing where they go, hey, we found DNA, Stephen Stern's DNA on her. There's no reason why that should be there. And let us see if where else might we find evidence about what we suspect is happening to Madeleine. Let's look at his digital profile. Yeah, I think they could probably get there. Great comment, Sarah Kerbo. Coming in clutch at the end. We've been at this an hour and 20 minutes, guys. Why have we been doing that? That's a long time. I'm grateful that you spent some time with me. Let's take a look at our subscriptions. Look at us. Look at us. We are a community of 115,361 fishies, which is pretty freaking rad. Thank you for spending your evening with me. The Rewatch crew, thank you for spending whenever time you're doing this with me. And I also know that so many of you are in other time zones. Got viewers all over the place. We've got Uruguayas in Australia, man. Got people over the pond in England. Speaking of over the pond, guys, don't forget, I think it's June 6th and 7th. I'm going to be at CrimeCon UK. I'm going to be speaking on the Ellen Greenberg case. Let's look for, if you guys don't know about the Ellen Greenberg case, it's okay. Going to be speaking on the Ellen Greenberg case with my pal, Joseph Scott Morgan. So if you're going to be across the pond, please come and say hello to me. I'm bringing my wife with me, so Kimberly will be there with me. And then we're going to spend some time together just to celebrate us and just to spend some us time together. Of course, I'm sure we will be checking in on the kids like incessantly, because every time we go away just for ourselves, all we think about are our children, which I guess is appropriate and good. Anyway, come and do that. Before we go, let me remind you over here on the website, okay? There's a support me page. So many of you support me, and I love it, love it, love it. Scroll down to the bottom. Take care of Autumn. Buy her a coffee, will you? She wrangles all of our moderators. She leads them like a knight dressed in shiny armor atop a golden stallion. She works hard, and I appreciate you taking care of her. Another way that you can help me without spending any money is to support the people that support me. If you go over to this little page, these are some of the companies that I really like, that I have affiliations with, that of course Irish Spring is there. Of course Cluvelta is there. Gotta do Cluvelta. Guys, get yourself a coffee mug, a Cluvelta coffee mug. Get yourself a tea. It is, in fact, Cluvelta sponsors this very murder board behind me. Pretty great. However you support me, I deeply appreciate it. I love that you're here. I love that you comment. I love that you share. I love it all. And I deeply appreciate you guys. We will be back tomorrow, 7:30 p.m. Eastern Time, to talk about, I'm thinking we're going to pivot over to the Kevin Mullins case, the Judge Mullins case. I think. So come back tomorrow at 7:30 p.m. Eastern. I hope to see you then. Until then, I bid you adieu, and I hope you take care of yourselves. Bye-bye. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.